Good morning, this is your Kelso Report for Tuesday, October 23rd. I'm your host, Clark Kelso. We begin today with an environmental law case involving the Endangered Species Act, and then turn to two cases of statutory interpretation. The first involving California's Lanterman Act, and the second involving the definition of street terrorism under the Penal Code. First, our environmental law case. Pipeline construction has become a major issue in the presidential campaign. Well, it is also an issue for the courts. And our first case concerns a decision by the Bureau of Land Management to authorize the Ruby Pipeline project, which involves the construction, operation, and maintenance of a 42-inch diameter natural gas pipeline extending a distance of over 680 miles from Wyoming to Oregon. The right-of-way for the pipeline encompasses approximately 2,300 acres of federal lands and crosses 209 rivers and streams that support federally endangered and threatened fish species. According to a biological opinion formulated by the Fish and Wildlife Service, the project would adversely affect 9 of those endangered species and 5 designated critical habitats. Nevertheless, the service concluded that the project would not jeopardize these species or adversely modify their critical habitat. The propriety of the service's no jeopardy conclusion and the Bureau's reliance on that conclusion in issuing its record of decision were challenged by the Center for Biological Diversity, the Defenders of Wildlife, and the Summit Lake Paiute Tribe, all of which raised concerns under the Endangered Species Act. The Ninth Circuit held that the service's no jeopardy and no adverse modification determinations were improperly premised upon certain protective measures that were promised to be taken, but that were not enforceable under the Endangered Species Act, because the promised measures depended upon action by a third party who had no legal obligation to the government to undertake the protective measures. You couldn't enforce those promises under the Endangered Species Act processes. So they had a plan, but not an enforceable plan under the Endangered Species Act. And that was not good enough to protect the interests under the Act. In addition, the Bureau also failed to take into account the potential impact of withdrawing 340 million gallons of groundwater from 64 wells along the pipeline. That is a lot of water to ignore. In light of these errors, the court concluded the service's biological opinion was arbitrary and capricious, and having set it aside as invalid, ordered the Bureau of Land Management to set aside its record of decision. The Bureau and the service will have to give it another try. Now we have two cases involving statutory interpretation. In resolving statutory ambiguities, courts often look to the overall purpose of the statutory provisions at issue or the overall program established by the statute. Sometimes the overall purposes provide only faint hints, but every now and then the overall purpose makes the interpretive choice clearer and easier. That is what the majority certainly thought in Harbor Regional Center versus the Office of Administrative Hearings, although the presence of a dissent naturally undermines the notion that anything here is really clear and easy. Technically, the issue before the Second District was whether the Office of Administrative Hearings had jurisdiction to enter an order directing a regional service center under the Lanterman Developmental Disabilities Services Act to pay a higher wage to an in-home care provider of a severely disabled girl. The answer to this jurisdictional question depended upon whether the pay raise request created a vendor pay rate dispute, as to which the Office of Administrative Hearing lacks jurisdiction, or was a service provision dispute, which falls squarely within the office's statutory jurisdiction. The problem in the case was that, absent the pay increase, services that had been found necessary and appropriate simply could not be provided. So is it a pay case or a services case? Well, faced with this conflict between pay and services, the majority consulted the overarching purposes of the Lanterman Act and found that one of the highest priorities under the Act is to provide minors with individualized services in a creative and flexible manner which allows them to remain at home. Concluding that this statutory purpose would be frustrated if the dispute between the parties were viewed as a matter of setting uniform pay rates, the majority held the dispute was actually a service dispute, over which the Office of Administrative Hearings had jurisdiction, and an individualized rate could therefore be ordered and made applicable in this particular case. We turn from the Lanterman Act now to the Penal Code, where statutory interpretation was also front and center in People v. Anguiano, where the 4th District had to interpret the scope of California's street terrorism statute. Now, the legislature has in recent years targeted gang activity and gang-related criminal conduct. Penal Code Section 186.22a provides that any person who actively participates in any criminal street gang with knowledge that its members engage in or have engaged in a pattern of criminal gang activity, and who willfully promotes, furthers, or assists in any felonious criminal conduct by members of that gang, shall be punished as a felony or misdemeanor. Subdivision B of Section 186.22 creates a similarly worded sentence enhancement. Well, the issue before the court was whether this statutory language applied to a situation where the defendant, a gang member, was sitting alone on a porch, and when he noticed police officers approaching him, attempted to flee from the officers through a personal use amount of methamphetamine over a fence and resisted arrest. It was undisputed that his possession of drugs and resisting arrest were not related to his gang. Now, the California Supreme Court had already held that street terrorism crimes under Section 187.22 do not have to be directly gang-related. So, for example, a rape committed by gang members qualifies under the statute. Well, the 4th District distinguished this Supreme Court precedent on the ground that the gang members acted together to commit the rape, while Anguiano was sitting alone on his porch, and possession of personal use amounts of drugs and resisting arrest had nothing whatsoever to do with the gang. The court explained that it simply did not believe the legislature intended to include within the meaning of street terrorism the crimes and the circumstance committed by the defendant. Now, we will all get a chance to see whether the 4th District is right or wrong, since this precise issue is currently pending before the California Supreme Court in People v. Rodriguez. So we'll see whether the Supreme Court agrees with this particular interpretation of the Penal Code. And that's it for today's Kelso Report. Have a great day in the law.